Good afternoon, everyone. I'd like to welcome you to today's webinar, which we've called the best webinar you will ever attend about export control. My name is Tom Reynolds. I'm a Vice President of Operations here at Export Solutions, and I'm going to spend the first few minutes doing some housekeeping things. We have a full session today, and a lot of people are still joining, and that's okay, because we're going to take some time in the beginning to go over a couple of administrative items before we dive into the material. One of the reasons we call this the best webinar you'll ever attend is because it's our longest running session. We've been doing free webinars for about 5 or 6 years now, and this one is always jam-packed, highly attended, and very, very popular among our folks. So one of the things I like to tell people about this, just as a heads up front, is this is an introductory session, and that means if you are still learning the world of ITAR and EAR and export control regulations, this is the right place to be. If you've been in this industry for a long time and you consider yourself to be more advanced and knowledgeable about these regulations, then the next 90 minutes is probably going to cover a lot of stuff you've already heard or are familiar with. But if you are just learning and just getting into this, we're going to start from zero and we're going to build your knowledge up. And by the end of this, you're going to know a lot more than you did when you joined. So we're glad you're here. Just a couple of things to go over in the beginning. A brief disclaimer that we like to put at the beginning of our sessions. And basically what this says is that the regulations themselves are the controlling source documents and the ultimate authority. We keep up to date on the regulations and are very knowledgeable about what's changing. However, these regulations do change. In fact, there's a slide here in a few minutes when we're going to talk about penalties, and they've just proposed some new penalties. And that's an instance where I think that the information that you'll see on these slides is not going to reflect what is coming down the pike in terms of penalties from the different agencies. So that's what this disclaimer just talks about, is the fact that we keep current on the information and we provide you with updates. But in any instance, when we say something or present something that is not consistent with the regulations, obviously the regulations themselves are the authority. Just a couple of things about how this webinar works. Hopefully you can all hear me and can see these slides. Unfortunately, with the last webinar that we had some technical difficulties, which I think we've overcome since then. But at any rate, we keep everybody on mute because there are hundreds of people on this call, and we've just found over the years that having all of the participants stay muted is the best way to ensure a seamless experience for everybody. However, with that in mind, we would like to have dialogue with you. And so the way that we manage that is through the Q&A questions box on your GoToWebinar toolbar or the chat box. So you should see a box called questions and another one called chat. Either one of those is perfectly fine. And as we go throughout this material, if you do have questions, we would like you to submit them to us. We're going to be stopping at various points and taking those questions. Everybody will be anonymous. I will not name names or name company names for the question, so you can rest assured with that your question will be anonymous, but we would like to address it if we can. There are some instances where some of the questions we get are pretty specific, and if any of you have been around long enough, you'll know that a lot of times the answers to questions when it comes to export regulations start with "it depends." That's one of the jokes we have within our group, is "it depends," because there's a lot of "it depends" that comes up, a lot of conditions, a lot of scenarios, and a lot of additional information that we may need. So if we get to one of those questions and if I skip it, don't take it personally. Just know that it's too detailed for us to get into on this particular call. However, we'd be happy to follow up with you separately in a one-off situation, find out some more information from you, and then try to provide you with the best guidance that we can. Our most popular question by far is this one that you see here, which is, can you email me the slides from this session? And we used to actually email the slides out, but we found a better way to do it, and that is we will post the slides on our website. And so if you go to exportsolutionsinc.com and you go to the section at the top called Webinars, you will see not only our upcoming sessions, but also all of our past sessions that we've ever hosted. And from there, if you go into the section called Archived Webinars, you'll be able to download a copy of these slides, and you'll also, we are recording this session, so you'll find a audio-video recording of this. So if there's anybody in your organization who didn't get to make it today or had technical difficulties and couldn't log into this webinar, you could always send them to that link on our website where they can view this entire session and, like I said, download the slides. The only thing that we ask is that you keep those slides within your internal company for internal purposes only, you know, and the only condition that we put around them is that you're not allowed to sell them or transfer them outside to another organization without our permission. So that takes care of the most popular question we get. I will like to talk to you about the next session that we have. We usually try to do about 3 or 4 of these per year, and I know there's a long jump between June and December, but right now the next one that we have confirmed is a session in December where we're going to provide you with an end-of-year review of the regulations and what's changed. Like I mentioned, particularly in the last couple of years, what we've seen is a lot more change happening in the ITAR and the EAR than in previous years. And so we thought this would be a good opportunity to recap some of those important changes for you. Like, for example, the ITAR just recently came out with a whole bunch of proposed new definitions for some of the key terms in the ITAR. That's just one example of one thing that's changed. But if you'll join us for this session in December, I think it would be a good opportunity for anybody who hasn't been able to keep up with everything to get a good update on what the changes have made. I'll tell you that these sessions are all free. And they are limited to 100 people. That's the capacity of the software. So it's a first come, first served basis. The first 100 people get in, and everybody else from that gets the recording. So if the end of your session is something that you're interested in, I would recommend that you sign up for it sooner rather than later to secure your spot. Also, I'll just put this out there as a teaser, but we are looking at having another session sometime between now and December focused on imports. So I don't have a date for that yet or a confirmation, but if you are on our distribution list for our monthly blog digest, or if you could check back on our website, I think at some point you will see us publishing a 4th webinar specifically around imports and import regulations. So just stay tuned for that one. Okay, at this point, I'd like to turn it over and introduce today's presenter. His name is Ray Castanero. He's a senior consultant for trade compliance at Export Solutions. And I'll just give you a little bit of background on Ray and his prior experience in his career. Ray has nearly 30 years of experience in trade compliance and contract compliance across a variety of roles, including empowered official, a certified professional contracts manager, a program manager, business development manager, and a U.S. government contracting policy officer. Ray's extensive career has focused on meeting regulatory requirements and achieving business objectives under the ITAR, EAR, OFAC, NAFTA, and BATFE, which is Bureau of Alcohol, Tobacco, Firearms, and Explosives regulations. And Ray is also a subject matter expert in the FAR and DFAR supplement for those of you who are involved in government contracting. His background includes working for some of the leading manufacturers of highly technical products and services, including aircraft, infrared technology, night vision, targeting, and surveillance systems. And we can probably add to that list just based on what I know about the clients that Ray's worked with here at Export Solutions over the last few years. Ray's a graduate of Rutgers University, and he served in the United States Air Force flying various fighter aircraft. He's got a lot of cool stories about flying fighter jets if you ever get a chance to talk to him. And he completed his career in the Air Force by retiring from honorable service as a lieutenant colonel in 2003. And we always like to thank Ray and all of our service members for their service to the U.S. military. In 2014, Ray accepted a commission in the State Military Forces of Texas, Air Component as a colonel. And he joins us now from deep in the heart of Texas, just outside of Dallas in North Richland Hills. How are you doing today, Ray?
I'm doing fine, Tom. Thanks for the introduction.
All right. Thank you.
Ready to get started?
Yep.
Okay. Tom covered all the housekeeping, so it's just time for me to just dive right into it. Okay. 5 major questions. You may be thinking about, or if you've just entered into the export compliance world, or thinking about it, etc. Why has export control become such a big issue? We'll talk about that. And what are your risks as a company and as an individual dealing with the regulations? What are the basics you need to get started? For those of you who are already into it, these are the basics that you should have had, but sometimes we find out that clients will come to us and say, hey, you know what, I really didn't know the basics. I went into this blindly. So we'll cover the basics for you so you have an understanding of those. How your company will benefit by addressing this issue, that's a key thing, that when you're setting aside funding, et cetera, or putting together a program, and your boss is anybody with the word chief in his or her title, what's the benefit to the company? And we'll talk a little bit about that too. It's definitely a benefit. By definition, reducing liability is a benefit, but there are other benefits as well. And then what the next steps will be on the road to export compliance. Okay, why is it such a big issue? Well, first of all, the regulations have been around for a little more than 30 years. My experience with all of this was kind of toward the beginning of it. So although I had mentors throughout my career, there weren't that many available, simply because it was a fairly new concept, or at least the system that we have today. But it does have 30 years of history, and there has been a lot of companies have had input into it, et cetera. The export control reform that's happened recently, starting in around 2013, has had a lot of industry input. And when the regulations are updated, you can look up in the Federal Register, companies that have had input into it, or if they've asked for something in a regulation and it was not granted or put into one of the changes by the government. There's usually a fairly decent explanation as to why it was not. But once again, if you're in this game long enough and you have enough expertise in it, you actually might have some input into the regulations, which is kind of nice. It's kind of good. Some more reasons why it's such a big issue. Of course, after 9/11, realizing we have non-state actors as enemies and potential enemies. Obviously, people who don't like us or want to do harm to us, getting hold of technology they should not have, or technology they could exploit to harm us or hurt us or kill us in some cases, it becomes very, very important. Most recently, of course, we've had the incidents in Paris and Brussels, San Bernardino, terrorist attacks. Once again, they involve firearms, explosives, and bulletproof vests, and God forbid, going forward, could be chemical, nuclear, biological weapons. I mean, as far as you can take your imagination and about this stuff, is pretty much as far as it possibly can go. We have regulations to try to at least make a good effort to keep that in check. Of course, there's been government activity in the realm of fines and penalties against companies. The litany of companies that have been fined and penalized, just as long as you can even imagine. We'll talk a little bit about that. And then, of course, there are flow-down requirements from prime contractors and original equipment manufacturers that require adherence to this. And so, obviously, they'd be flowing it down to you to keep themselves covered, but it keeps you covered as well. And it is a requirement that these regulations, they're a matter of law, so you do have to follow them. And it really behooves you to understand them. Okay, let's talk about risk to your company and where your company is. Let's just say, for the sake of argument, the little green bar there is where your company is right now. As you can see, there's a big long spectrum. I don't know if you can see the mouse here or not, but this is the future going forward, and here's where you are right now. And this is presuming, of course, that you're taking this seminar because you have no program in place, or you're just thinking about getting into the export compliance world. So the assumption at the very beginning, either where your company is now or where it may have been in the past, is you don't have any knowledge of the regulations. You don't have a system in place. You really aren't in compliance with the regulations because you don't know what they say. And you could possibly have some violations that you don't know about. Well, your risk of violations is about like that going forward. That big, huge risk to the company because, again, all of the no's and no knowledge, no system, no compliance, your risk is very, very high. And if you've been in business for any length of time, you understand that risk equals money in most cases, either in fines, penalties, or lost revenue, lost business, etc. So there is a definite risk to the company. Okay, now if your company is here, you have some understanding. You have a partial system in place. It may even be an anecdotal system. You just have, yeah, that's Joe or Sally's realm. You know, if you want to ship something to Europe, go talk to them and they'll keep you straight. You know, it's not a formal system, but you may have something. Some of it may be in writing. Some of it, as I said, may be anecdotal or tribal knowledge within the company. But you have something at least going for you. You have basic compliance. Still, you have to be aware that even if you're in the middle here, you know that you have some understanding, partial system, etc. There may be some potential violations that you are either aware of or not aware of. And of course, the part that came before where you are now, green meaning good, you know, the pinkish red meaning not so good, is that you have some due diligence going forward. Either you were acquired by another company, or you have acquired another company, or you were a startup. There's a lot of ways to do due diligence, and when you think of due diligence, that is a legal term. Before you purchase or sell a company or are purchased or sold yourself, you know, there is a legal requirement for due diligence that involves, you know, companies merging and acquiring one another. So that is a legal term. The term we like to use in the export compliance world is that you've taken reasonable care. Again, as you're looking at all of these things that we're going to be talking about here in the next, you know, the rest of this hour, just keep in mind that the government is not expecting you to be perfect. No one is, even not the government, of course. But taking reasonable care is what is expected of you as a company, and that equates to the legal entity of due diligence. Okay, now if you're kind of advanced in this, and Tom had mentioned in the introduction that you're not going to see a lot of new stuff here if you've been in the business a while or if you've been doing this. So let's say you're to the far right of this scale as far as system and everything. You have a full understanding, you have an implemented system, you're in compliance, violations are minimized. Notice we don't say non-existent, they are minimized because that's what all this is about. That if you have violations, they may be mitigated by, you know, positive things you've done, etc. So if your company is there, you've had about that much due diligence going forward. You have a export compliance officer. That person is senior enough in the company to actually have input into the company's dealings. You're higher up, upper management, CFO, CEO, COO, CTO, etc. All these people with chief in their titles. You know, they've taken positive steps. And then if you look at it, if you are here, that's about as advanced as most companies can really be. The little risk bubble is much smaller, but once again, keep in mind it does not go away completely. Violations are minimized and or mitigated by the measures that you have in your understanding. Oops, back up here. Okay, so that's if you've been in the business for a while and you've done your due diligence. Now, does a foolproof system exist? It's probably not practical. Export Solutions would probably not be in business if such a thing were possible, because at some point somebody would crack the code and had to be perfect. So, you know, being perfect would only work in a perfect world, and as we know, we don't live in a perfect world. There are people involved, unless your company's entirely populated by robots or cyborgs of some kind. You have people, and people do make mistakes. However, that all being said, a robust system will catch mistakes, either as they're occurring, before they occur, or very shortly afterwards. A robust export compliance system will make prompt and accurate disclosures to the government. You know, we've heard of them as voluntary disclosures or voluntary self-disclosures. That is not only an accepted practice, but it is expected of you by the U.S. government, both the State Department, the Commerce Department, and the Treasury Department that if you see that you've done something wrong, that you own up to it. Think about any of you who are parents. You know, if your child comes forward and says, hey, I stole a cookie from the cookie jar, the penalty is going to be a lot less than if the kid denied it. And, you know, you found the crumbs on said kid's clothing or toys. So there you go. So in other words, a robust system will definitely have the provisions to make accurate disclosures to the government. As a result, with such a system, your potential for fines, penalties, etc., will be greatly reduced. Of course, nothing ever goes away completely, but essentially, the U.S. government is not trying to be in the business of nailing as many people as they can and throwing people in jail for no reason. They want you to be compliant, and if those risks and penalties exist as a threat to some people, and that's what it takes to keep them compliant, well, then the government's all for it. Obviously, they would prefer if you're diligent, and if you have due diligence and you exercise reasonable care in your export compliance activities, your risk to the company is much, much lower, and overall, you're going to be a better company for it. Certainly from a compliance standpoint, but realistically speaking, also from a longevity standpoint. Companies that don't make these major mistakes and pay fines, et cetera, tend to last longer and have a better business model than those who do not. Okay, here's a couple of enforcement actions. The last full year that we have the data for is 2015. The Office of Foreign Assets Control, OFAC, which is kind of the regulatory and enforcement arm of the U.S. Department of the Treasury, had a fine $277,000 against Guidant Corporation to settle allegations of violating the Iranian transactions regulations and some Iraqi sanctions. And if you look at it, it went on from July 2000 to July 2004. So that's 4 years of problems that these people had. And I don't have the details up here on the slide, but essentially the government was able to discover this either through self-disclosure or investigation. But one way or the other, chances are, since there was a penalty of $277,000, it would be a very, very safe bet to say that this company did not cooperate well with the government, was not seen to be duly diligent, did not exercise reasonable care, etc. And of course, when we talk about OFAC and Department of the Treasury, whenever you're listening to the news or reading the news on your news feeds or however you get your information, when you hear about sanctions against people and that there are certain sanctions against Vladimir Putin and his cronies in Russia, etc., it's the Department of the Treasury that does that. If it involves withholding money, funding, or preventing people from certain banking transactions, it's to punish them to enforce U.S. law, and that's where this came from. So this company, decided at some point to turn a blind eye toward the regulations, try to make some money by dealing with Iran and Iraq against the sanctions. So they got caught somehow and they got fined. The next one down the middle, Bureau of Industry and Security, the BIS. That is the enforcement regulatory arm of the U.S. Department of Commerce. Yamada America Company paid $220,000 U.S. in civil penalties for unauthorized exports. So basically, it's an Illinois-based company, probably Japanese, wholly owned subsidiary of a Japanese company, was assessed $220,000 in penalty in connection with the export of diaphragm pumps to Taiwan, Singapore, Brazil, and Ecuador without required licenses. It's interesting to note that it's Taiwan, Singapore, Brazil, and Ecuador. We're not talking about Vietnam, Cuba, China, Putin's Russia, etc. These are quote unquote friendly nations, and the nations that we certainly trade with and everything. But there are times under the Department of Commerce regulations when licensing is required, and in this particular case, Yamada America violated those laws and had to pay a civil penalty of $220,000. The bottom one is Directorate of Defense Trade Controls, one that's nearest and dearest to my heart, the DDTC. That is the regulatory and enforcement arm of the U.S. Department of State. For those of you who have heard the term ITAR, International Traffic in Arms Regulation, these are the folks who write it, maintain it, and enforce it. This one is I like this one to look at because you're involving people who are knowingly doing wrong. These people are criminals. It was a smuggling ring. In addition to whatever other penalties for smuggling that they're involved in, they were also sentenced. And when we see sentenced, that means jail time for arms trafficking and money laundering. And then you see some of the names: a person from Singapore, somebody from Indonesia, another person from Indonesia, and look, there's a person from the United Kingdom. So there's no only certain people from certain countries and only people of certain nationalities get involved in this. A smuggling ring is a smuggling ring, and they were sentenced by the U.S. District Court. I guess this happened in and around Detroit, and for violation of the AECA, which is the Arms Export Control Act. That is the body of law that pretty much created around 30 years ago these regulations and doled them out to the three departments: Treasury, Commerce, and State. So you're in violation of the AECA by violating the regulations. Apparently, these guys attempted to buy some defense articles, including radar, military aircraft guidance parts, machine guns, and smuggle them out of the United States. Money laundering is one of those add-ons that the government loves to do, because if you're dealing with ill-gotten gains and you're trying to put it out there into the economy, that is by definition money laundering. So if you've committed any of these other types of acts, they almost always tack money laundering onto the end of it, and it has its own pretty substantial penalties. And of course, it says they've been statutorily debarred by the Department of State for 3 years. Some of these people probably won't see the light of day for longer than that as far as prison terms are concerned. But if they were involved either with companies or et cetera, if you're barred by statute from the Department of State, that means no exporting, no dealing in goods that are required to have export licenses based upon the International Traffic in Arms regulations, et cetera. So the penalties, essentially, the enforcement is real, it's there, and people are paying the price every year. I got to back up again. Sorry about that. I was gesticulating with my hands, and wow, I went forward. Okay, there we go. And I accidentally hit the mouse button. Okay. Past enforcement actions going back to like 2010. You can see China nuclear industry washing. I believe is how that's pronounced. $3 million for violations. BAE, a company you may either be a part of or deal with, British Aerospace in the UK, was denied export privileges, $400 million for conspiracy, false statements, and robbery. These penalties, I remember when we used to train people, and the record fine ever paid was $110 million by ITT some years back, and now this is ridiculous, $400 million, almost $500 million in fines. So when the government goes after somebody, obviously, if you're a mom and pop operation, they're not going to go after you for $500 million because you don't have it. But somebody like BAE or one of the larger companies in the world with the deepest pockets, the government is going to let the punishment fit the crime and let the punishment fit your ability to pay the fine. They have that leeway in these cases, so that's a lot of money. Aeroflex, Raytheon. We go down the list. United Technologies. BAE Systems down there again. You see sometimes the same names appearing on these lists from time to time. But then you go down to a company that I certainly have never heard of, Pittsburgh Plate and Glass, $3.75 million for export administration regulation violations. So these things are real. The government takes it very, very seriously, and you should as well. Here's a case study, Key Optic. We know some folks who were able to provide us this information. It is publicly available information, but we have some pretty good insight into this. Key Optic is a Luxembourg registered company. They were convicted of 163 violations of the ITAR, International Traffic in Arms Regulation. It started with a voluntary disclosure to the State Department, and this was a statement that was from the case itself. Had the department not taken into consideration as significant mitigating factors the respondent's voluntary disclosure, and respondent, by the way, would be Key Optic, the fact that the violations were committed prior to the Key Optic Group acquisition of the violating business units and the remedial measures implemented, I'll explain this in a second, the department could have charged the respondent with additional violations and could have pursued more severe penalties. So they don't always go for the maximum, But you know, of course, like with any kind of legal criminal action, they have to prove it in court. But basically speaking, you're talking about there were some mergers and acquisitions of other business units that had violations, and the corporation that eventually became Key Optic did not perform their due diligence. And so what happens is, whenever a company is acquired, if there are violations that have been unknown up until a certain point, somebody in that transaction, whether it's the people who sold the acquired entity or the people who bought it, the company that bought it, has to have responsibility, has to be the successor of interest for any violations. There are no loopholes that say, well, these two companies merged, so therefore one of them's violations just went away and disappeared because nobody's responsible. Somebody's going to be held responsible. And part of the due diligence you should always do, again, in any kind of acquisition situation, is you have to establish who the successor of interest for any violations is, because the government is sure going to know, you know, if those violations do come to light. So you don't want to be the one holding the bag the way Key Optic did in this case. A little bit more history on the same case. December 2005, Key Optic purchased a bunch of companies from Thales, High Technology Optic Group. They kind of split up and sold off various business units. Key Optic wound up with a handful of them. The day before the purchase, yes, this is due diligence, but boy, it's cutting right down to the wire. You know, the day before the purchase, Thales filed a voluntary disclosure with the State Department, and it involved the illegal export of night vision technology and data, keeping in mind that night vision technology is one of those buzzwords, or it's one of those technologies that the U.S. government is very, very interested in. That, missile guidance, anything involving targeting, target acquisition, etc. But night vision, it used to be said up until, I want to say maybe 15 years ago, maybe 20, we owned the night. The United States really was the only country in the world that had night vision technology, and we certainly have the best. I mean, I don't even know what generation we're up to in night vision, but you know, the U.S. certainly has the best night vision technology in the world. We pioneered it. Others, you know, through either stolen or illegally acquired technology, or even their own research and development, have it now. So we can't say that we own the night anymore, but you know, we own most of it, I guess, would be the takeaway on this. And of course, the Key Optic violation, back to this slide with the third bullet, included unauthorized exports to France, Israel, Singapore, and China. China, very problematic in and of itself, because we have embargoes against China of military technology. Singapore, Israel, France, not so much as far as the country's concerned, but once again, we do try to protect our technology. And you know, regardless of whether it was China or France, you know, two different ends of the spectrum as far as ally versus potential enemy, you can see that the government takes it very seriously, any violations. Thales was accused and eventually convicted of using third country nationals without proper technical assistance agreements in place. If you deal as a company with third country or dual nationals, etc., and you deal with export control technology, if you don't know what the term technical assistance agreement is from the Department of State, you may be, if you remember those slides we talked about, small due diligence means big risks, you may find yourself way on the far left of that slide if you don't even know what the term means. So just heads up there, TAAs, very, very important, and Key Optic paid a price for not having them in place. They treated items as if they were subject only to Singapore law. The Strategic Goods Act, I think Canada has their set, and the UK probably originated it. Essentially, this is their version of the ITAR, but it is not the ITAR. The ITAR is the US regulation, and that's ultimately what was violated here by Key Optic. There were other unauthorized exports and re-exports to Iran, Cyprus, Russia, Germany, and Hungary. Once again, you see the kind of the full spectrum in there. Iran, of course, has sanctions against it. Russia has some sanctions after the annexation of the Crimea and portions of the Ukraine. So Russia has some things against it. Germany, you know, ally, NATO country, etc. But once again, certain exports do have to be, and re-exports have to be authorized, even to a friendly country like Germany. Cyprus is a NATO country, but not all NATO countries are created equal, etc. So in other words, if the government finds out and that these things have happened, the penalties are going to be different levels for different countries involved, based upon the harm to the potential harm to the United States. But once again, you're not going to get away with anything simply, oh well, it was only Germany. So just keeping that in mind. I don't think there were too many more slides on this Key Optic case, but Department of State, and that's when it says state, that's what we mean, charged that Thales lacked a proper export compliance system. This is a direct quote from the finding of the case, which, by the way, as I said, is public record. These internal records describe business units involved in ITAR-related activities with limited or no ITAR training and a long-standing lack of support for ITAR compliance. There's a key there. If your company is not serious about ITAR control, if they hire somebody and that person, reports to somebody in the company who's responsible for profit and loss, schedule, etc., that's not considered to be a valid relationship. It may work for you for many, many years. You may never actually get caught, if you will, doing it, but there have been cases decided where they look and they go, yes, you had an empowered official, and yes, you hired somebody who's knowledgeable of the ITAR, but if that person made an unpopular decision that cost the vice president of whatever his or her bonus for the year, so therefore they didn't enforce it, well, that's intentionally turning a blind eye to make a profit. You don't want to be in that situation. And that was found to be the case here. A lot of times you'll see in these cases that are adjudicated against companies, they'll say you had $2 billion worth of government programs. And if you add up your entire effort to include the salaries of your staff, your training seminars, how much money you've put into people keeping up on regulations, only comes out to like $100,000. And they'll even look at it from a dollars and cents and say, you thought it was worthwhile to spend $100 grand to get $2 billion worth of business. Well, shame on you. No wonder why you had violations. So even though you can't always equate dollars to effort and due diligence, it is certainly a factor that enters into it. So I'm not saying that the solution is to pay your export compliance officer $500,000 a year. Of course, as one, I would love to have that salary, but nevertheless, dollars can be an indication of intent to follow the regulations. Now, of course, with Key Optic was further evidence by 2003 internal training presentation, where essentially Thales employees were told to avoid making disclosures due to a risk of discovery. So, I mean, although they had a training program in place, the training program told people, shh, mum's the word, don't tell anybody that we're doing wrong. So that's pretty bad. That's one of those intentionally turning a blind eye. I mean, that goes beyond it. That's malfeasance. That's professional malfeasance, and that's why this case is on these slides. I guess there is another one. In fact, there's two. I think there's two more. Anyway, August 2003, email from Thales SA to Thales in Singapore. I'm not going to read you this quote, but here's a quote. The red parts of it are kind of key to the phrase. This refers to as self-blinding, willfully turning a blind eye to the regulations, and that is a no-no as far as the government is concerned. So once again, we're not saying company ABC, it's Thales, and then Key Optic. So your name goes up in lights when you do this kind of stuff. So it's a key takeaway here. Please notice in August 2003 emails can and do become evidence in any case. Emails are forever for the most part. Attorneys hate them. You ask any general counsel, and they're going to say, they long for the days when monks with big feathery quills wrote down everything by hand, because at least people were careful about what they put into writing. Well, emails, people, will put a throwaway comment to an email that winds up hanging their company in court. So once again, your emails do become evidence in any subsequent cases. Hopefully you already realize that, and you're very, very cautious and careful as to what you put into writing. I'm not telling you to don't put it in writing and do it anyway. What we're saying is that if you're doing something wrong, your emails are going to be evidence used against you. Email is not your friend in most cases. And then here's kind of the results. Key Optic paid $25 million in fines and remedial compliance. They had to go out and hire a special internal compliance officer to oversee export compliance. This was a staffed position that they didn't have in their budgets. Once again, when the government says Like you're paying some low-level functionary to be your export compliance officer. Well, they had to go out and they were required, by the court to hire I would imagine a fairly highly paid internal compliance officer, somebody with years and years of experience to oversee their export compliance. Once again, they're paying for it. The government is not. So they didn't have it in their budget, and I'm sure all these fines and penalties weren't either. They were required to do yearly reports to the State Department outlining their compliance costs. Once again, having not a whole lot else to go by, the government says we want to see how much money you're spending on compliance to see how seriously you take it. So once again, it becomes a factor. They had a government direct oversight of its compliance program. That's what we refer to as a consent agreement, where you consent to have the government overwatch you for whatever the duration of the period is that the court decides that you need to have oversight. Their legal department had oversight, which I'm sure made their general counsels very upset. And then there were on-site reviews of compliance efforts by State Department officials. Basically, for once you get one of these consent agreements, you are laying open your company's closets and letting the government know what skeletons are in those closets, and you even have to show them the graves where the bodies are buried. So it's very, very serious if you get caught this way. Here's, basically the takeaway that everyone should understand: violations are vigorously enforced. Here's a screen snapshot from the Department of Commerce. For those of you who use the internet a lot, of course, these are all links. On this slide, they're not because it's a snapshot, but you can click on these, and here's a little book called "Don't Let This Happen to You," and then this one here is a real key: Department of Commerce Major Cases. So you can actually click on this, download this free booklet, print it out, or read it on your screen, or however you wish. But it actually names names, dates, places, fines. That Key Optic case, this one here, would certainly be listed in that book. And as I said, when I say it's a matter of public information, it's in that book, which is right here. There's the "Don't Let This Happen to You" booklet. The government's been using that scary phrase probably since World War II to keep GIs in line, but it does work. I mean, it's a good enforcement tool. You don't want your name up in lights in this book, or you don't want to be at the SIA, Society for International Affairs conference one year and have your company representative be the keynote speaker because your company paid a $200 million fine. You never want to be that company or that person. Here's another place. This is the Department of State's site. We do have, of course, snapshots of more recent versions of this, but I like to use this one myself, even though the most recent date it has is 2013, simply because of the three names that are here: Megit, Aeroflex, and Raytheon. These are companies that you either work for currently, you have worked for in the past. They may be customers of yours in the case of Raytheon. They may be suppliers of yours, Megit USA. I mean, every company I've ever worked with that used high-tech technology and electronics has had Megit as a supplier. So there you go. These aren't Shady Joe's garage operation. These are real companies that real people like you deal with on a day-to-day basis. And boom, you can click right on this and look up all of their sins and foibles. Of course, you can click on it by year. Please note that the by year stats go all the way back to 1978, and then undated would be prior to 78. So these cases and essentially your name being up in lights never goes away if you have a violation. And then just to fill out the triumvirate of the three agencies, this is the Department of Treasury's site. They all handle how their website works a little bit differently, but the key here is these are PDF documents, and you can click on these and actually download the detailed penalties information. You can have actual case files. You can see what went on in court. Once again, you can't hide this stuff once you're in violation. We mentioned penalties. I want to harken back just for about a second to what Tom had said earlier. These are currently being reviewed by the government. When we talk fines and penalties, we'll talk about the numbers as they are now, but keep in mind that the government is reviewing them, and if you know anything about the government, chances are fines and penalties are not going to be reduced. They're probably going to go up, but anyway, it's being considered. So there are fines. Debarment, I touched on that earlier. means you're not allowed to export or sell to the U.S. government. To most companies, that's almost a death sentence. I mean, if you're, 80% of your business depends on selling to the U.S. government, and you get debarred for 10 years, or 5 years, or whatever, that's kind of a death sentence. So you don't want that, Imprisonment, I have that boldface because that is something of all of these things here, the one that I would want to avoid more than anything would be imprisonment. So if you don't want to go to jail and wear an orange jumpsuit, there you go. There's incentive enough. Keep in mind, of course, that you can't imprison a company. You can only imprison people. So yes, they do go after individual people who work for companies. You are not, you're not innocent of a crime if you commit it on behalf of your company, or at least just because the company pays a fine, it means you get off scot-free. The government goes after individuals. Whoever they believe committed the act, they're going to go after. And it's going to be companies for money, usually, and it's going to be imprisonment for individuals. So just keep that in mind. I don't want to beat that to death, but you should be a little scared, at the very least, of that. Government oversight, we mentioned that in the Key Optic case, in the embodiment of a consent agreement. Once again, you may be required to staff an external auditor. They can require U.S. government to representative to be at meetings. The philosophy or the credo of these kind of people who are placed in your company is, number one, they're a U.S. government representative from the Department of Commerce or state or wherever your violation was. Whatever that jurisdiction is, they're going to send a person to your plants. That person is going to pick out a nice office, and maybe the office that your vice president of engineering currently resides in. Say, yeah, I'll take that office. Make sure I have a phone. Make sure I have a laptop. Make sure I have an access to all of your systems, et cetera. And all this is coming out of your pocket. So it's a big deal. And then their credo, of course, is any meeting that they're not invited to, they're going to crash. So if you're under a consent agreement, once again, there are no more closets with skeletons in them. The skeletons are out for all the world to see. As I said, penalties can be civil and or criminal. And penalties can be imposed against both companies and individuals. And of course, they are matters of public record, so you can't just pay the fine and hope that nobody notices. This is the slide. These are the numbers that may be changing soon, but these are the current numbers under the Export Administration regulations owned by the Department of Commerce. $250,000, the greater of $250,000 or twice the value of transactions. Criminal violations may be up to $1 million, and or 10 years imprisonment for individuals. Obviously, as I said, you can't imprison an entire company, although if the government could find a way to do it, they might. The ITAR, International Traffic in Arms Regulation, is under the jurisdiction of the State Department. Their civil penalties are double what they are for commerce, $500,000 per violation, and then criminal fines up to $1 million per violation. Now, when we say per violation, it is per violation. If you have something that you did, the single act, like such as exporting product 123 without a license, and you did it 100 times, that is 100 counts of that violation. So these numbers can add up very, very quickly and get very, very large. I mean, to me,
Ray,
yes, sir.
It's Tom. I just wanted to jump in here. Yeah. I was just reading the notice on the changes that I mentioned, and it's under the ITAR for civil penalties. As you said here, they're $500,000, and they're going up to, depending on which part of the Arms Export Control Act is violated, it's anywhere from $795,000 to over $1 million per violation now for civil penalties. So it's as much as double. And
so it didn't go down. It didn't go down, huh?
It did not go down, and they cited inflation as the reason for increasing the penalties.
Well, there you go. There you go. Yeah. So no, we're kind of laughing about it, but it really isn't a laughing matter. But it's, I'll tell you what, it gets expensive for sure. Okay, and here's another thing that could happen to your company, and this is sort of more esoteric. Your reputation's at risk. If you have any degree of patriotism whatsoever, you could threaten U.S. national security. Let's say if you revealed night vision technology to one of our enemies or potential enemies, that could be used against our troops. It can wreck your business, either a violation, a penalty, or debarment. Certainly ruin your reputation. If you recall the slide that had Meggitt, Aeroflex, and Raytheon on it, if I were doing my due diligence before I dealt with one of those companies and they had a recent violation, you better believe I would look at it, and I might take my business elsewhere if it looks like I'm dealing with a known violator. And then, your customer is not going to have a whole lot of confidence in you if you've been caught as well. You don't want to see your CEO with handcuffs on doing a perp walk on the 10 o'clock news, and you don't want your customers to ever have to worry about that as well. Okay, we're going to pause here for questions. So, Tom, if anyone sent you any questions and you want to read them or whatever, I will mute until I'm ready to answer them.
So far, no questions. I mean, we've had a few technical questions from folks, but nothing to bring forward at this point. So just a reminder for everybody, if you are listening in and you do have a question or something comes up that you'd like us to address, please submit that via the questions box or the chat feature on your GoToWebinar toolbar. And we'll keep moving forward and pause again here in the next few minutes and address any questions that come through.
Okay, good. All righty. That means, by the way, did Tom mention there's going to be a quiz at the end of this where you're going to, no, I'm only kidding. The only quiz would be if you ask us questions, but hopefully maybe that woke somebody up. Okay, some of the basics of export control. I'm going to talk about what an export is, and just kind of a little spoiler alert here. The definition of export has been changed recently. It's in the most current version of the ITAR, which only came out this week. These slides are a little more basic than that. The essential definition of an export, it hasn't changed that much. What they've done is they've honed it, made it a little bit finer, less gray areas, and a lot easier to understand. But essentially, the definition of an export is essentially intact. We're going to talk about what the ITAR is, what the EAR is, what the OFAC is, and just a little appeal for the importance of product classification. Okay, well, what's an export? Basically anything that's sent by any means from the U.S. to a foreign destination. That's the classic definition of an export. I think a 6-year-old would probably get that question correct on a test. It includes non-U.S. origin goods. If something has come and originated in, let's say, France, such as a helicopter, helmet targeting system, whatever, it's French technology, everything about it is French. As soon as it touches U.S. Soil, as soon as it's in the U.S., it becomes subject to the ITAR because the technology itself, regardless of its origin, would be controlled by the ITAR. Any U.S. origin item that's re-exported or retransferred from a country outside the U.S. Is an export. U.S. technical data or product provided to a non-U.S. person, even if it's in the U.S. So if I, give or impart technology to someone who's a foreign person on U.S. soil, that is still considered to be an export. Most people do not realize that. Well, a lot of people don't. And disclosure of restricted technology to a non-U.S. person. The EAR refers to that as a deemed export. So nothing's physically changed hands, but somehow, some way, technology was imparted from a U.S. person to a foreign person, whether it's on the phone or just from somebody's voice to somebody's ear. It doesn't matter. That's a deemed export. Exports can be done many ways. They can be tangible and intangible. Tangible is putting something in a box and sending it somewhere. Computers, laptops, CD-ROMs, flash drives. There's no limit to the medium. Media, if they come up with a new way of transferring data that nobody's even heard of today, kind of like the way a flash drive was several years ago, it's going to be covered. There's no loopholes. There's nothing to say, if I come up with a new way of transporting data to somebody, it's not going to be covered by the regulations. No, it's very, very clear. It says by any means. Intangible, of course, oral or verbal, visual, electronic. As I really have to stomp my foot on this one. There are no loopholes in these regulations as to how you can do something to get around the regulations. Okay, what is an export? We talked a bit about it with this definition, the who and what you need to think about. There's a question here. What's an export? Am I exporting something? Even if you don't send hardware out of the country, if you think about deemed exports and you think about all these other ways, something even by telephone, et cetera, you could be an exporter and not even know it. And then, of course, here's the laundry list of how You may be exporting and not realize it. You may have non-U.S. employees. Once again, those would be deemed exports. Customers, if you don't screen your customers, you may find that they're on a denied parties list, or worse, not find out that they're on it and you're still dealing with them. That's an illegal export. Email, as I said, email's forever, and it's just as if you engraved it in stone. I mean, you send somebody an email, that's you're exporting to them if you put any kind of technology in it. Casual phone conversations, letters, documents, or even regular snail mail. You stick a stamp on something, sending it to somebody, that's an export. May be perfectly legal, but it's an export. And then visitors or potential customers, somebody coming on a tour of your factory, and they see some ITAR-controlled drawings that one of your employees is working on. If they can glean any information from that's an export as well. Information on your company's website, you should vet everything you put out there in the public domain. Just because something is on the web doesn't mean it's legally supposed to be there, so you want to be very cautious about what you put on your website. Downloading from the internet, if somebody downloads it from your site, that's an export if they're a foreign country. And then data on your computers, networks, hard drives, etc. A lot of people don't think about the fact if you take your laptop out of the country, everything on it could possibly be exploited or stolen by somebody. So there are certainly measures we help clients with every day on international travel with laptops, smartphones, etc. So all of these things, there's a lot to consider when you think about how an export can take place. U.S. person is not an export. So if I send you something and we're both U.S. persons working in the same office, or you're my customer or something, and we import data to you, that's not an export. U.S. to U.S. is not. Now we talk, what is a U.S. person? Well, anyone who's a U.S. citizen or anyone who's permanently, legally allowed to reside in the United States. We've heard of them as green cards. Someone given political asylum. There are many ways that somebody can legally be allowed to live in the U.S. For export compliance purposes, that person is treated as a U.S. person. What is a foreign person? Is basically anybody who doesn't fit that first definition. If somebody's not a U.S. citizen, legal resident alien, doesn't have a green card or an asylee card, etc., keep in mind, here's just kind of a good rule of thumb, anybody who requires a visa to be or work in the United States or study in the U.S. is a foreign person, even if they've been here for 10 years. If they have to be on a visa, they're a foreign person for purposes of all these regulations. Any foreign destination, a foreign destination would be any country or company other than the U.S. There are foreign companies that are legally allowed to do business in the U.S. They're treated as U.S. companies, but that's getting into the details that we deal with on a day-to-day basis. Like, for instance, BAE North America is considered a U.S. company because they've been vetted. They have necessary firewalls in place between them and their UK owners, et cetera. So there are ways that foreign companies set up U.S. Corporations, and they are treated as U.S. corporations for these purposes. But, that's not for you to decide. That is, generally speaking, they have, the U.S. government has acknowledged that they're to be treated as a U.S. company. And just here's a little illustration of the difference between an export, a re-export, or retransfer. Export from the U.S., in this case to France, any other country, doesn't matter which. A re-export would be from France, in this case to Russia, meaning it involves a third country. And then a retransfer would be within, the foreign country. So in the case of this export, I made my widget in Kansas, sent it to France, that was an export. France sent it to Russia, that was a re-export. And then within Russia, it was sent someplace else in Russia to a different company or government entity or whatever. That's a retransfer. In the case of ITAR and commerce or EAR controlled items, all of these must be considered. The ultimate end use and end destination must be considered when either dealing with licenses or exemptions or exceptions. Okay, I mentioned deemed export. That's a U.S. person who is dealing, in this case, with EAR restricted technology, and they impart that to a German national. Could even be in the U.S. That is a deemed export. Nothing's changed hands. There's no piece of paper. There's no file or anything, but I've just explained technically enough to this German national, and so that now that foreign person has that knowledge. That's a deemed export. And it's a term that is pretty much defined by the Export Administration regulations. The same kind of rules apply to the ITAR, but they don't call it a deemed export. The ITAR is just very, very black and white. It's either an export or it's not. They don't really care if it's deemed or not. If it's an export and it needed a license, you just violated the ITAR. So the definition, the EAR has provided us with a nice definition of a deemed export. A deemed re-export, again, a third country is involved. So you got the U.S. person who exports something to a German national, once again, just sort of on U.S. soil, just imparts this technical data, and then that German national re-exports it to a Japanese national. Keep in mind, all three of these people may be sitting in the U.S. Doesn't matter. If you have a violation, something was illegally exported, the deemed export and deemed re-export all took place in the U.S. Doesn't even matter. Doesn't matter where it happened. So that's a deemed export, deemed re-export. These are the big three agencies that are involved with exports: Department of State, Commerce, and Treasury. State deals with defense items. The Department of Commerce, dual use items. Dual use means it's essentially civil in nature, but it can also be used by the military. Department of Treasury, OFAC, deals with sanctions lists. And you can see there's state deals, they have the U.S. munitions list, which is under the ITAR. That's how they control items. And licenses are determined by the item's classification under the ITAR. Department of Commerce has the Commerce Control List. That's their version of the USML, if you will. Much more complicated, much bigger. If I were to print out the entire ITAR on 8.5 by 11 paper, the entire regulation would maybe be an inch thick, 3/4 of an inch, something like that. If I printed out the Department of Commerce EAR the same way, it would be probably a document maybe 3 or 4 feet thick. I mean, it's huge. If you think about it, the ITAR only has to cover defense items. Commerce has to cover everything else. So that's why the EAR is much bigger. And then licensing there is determined by destination for that item, and certain items have certain controls. And it's much more complicated than the ITAR because it has to deal with many more types of things. And then the Department of Treasury, of course, jurisdiction applies to all U.S. persons and companies. So Department of Treasury, that's when you hear that there are sanctions against a certain country. You can't do business for sanction reasons. That's the Department of Treasury's bailiwick right there. As I mentioned, the ITAR, EAR, and OFAC, that's in order: Department of State, Department of Commerce, and Department of the Treasury. Those are the regulatory bodies that they use to control exports and imports. All right, a little bit more expanded. I'm not going to read the whole slide to you. ITAR, EAR, and OFAC, once again. ITAR is interested in defense items, has the U.S. munitions list, and then DDTC is the arm of the State Department that controls the ITAR. The EAR is under the Department of Commerce, dual use or commercial applications. It has the Commerce Control List. That's its list of items. Very, very big, very complicated, very complex, and difficult to understand. And of course the BIS, Bureau of Industry and Security. That's the arm under the Commerce Department that takes care of the EAR, that writes it, rewrites it, updates it, and enforces it. Department of Treasury, of course, has the Office of Foreign Assets Control, OFAC. You may even hear that term on the news from time to time. I imagine most civilians don't know what that term means when they hear it, but that's when they're using money to exercise U.S. control over countries. And there are various reasons. There can be laws, executive actions. I mean, there's lots of ways that somebody can be put on the sanction list of the OFAC, but it is Department of Treasury that takes care of it. Okay, this is the ITAR. For those of you who like big, long things, it's 22 Code of Federal Regulations. Chapter, that's a Roman numeral 1, not an L. Subchapter M, blah, blah, blah. But parts 120 to 130, that's the whole ITAR. It involves permanent export, temporary export, and temporary import. The reason there is that the understanding is if something is temporarily imported, such as I mentioned the French-designed targeting helmet, it has to be exported. If it's temporary import, by definition, it has to be permanently re-exported. In theory and understanding-wise, if something's permanently imported to the United States and it's military technology, the ITAR doesn't care about it. Bureau of Alcohol, Tobacco, and Firearms and Explosives might be, and other people might be interested, but the ITAR only controls temporary imports on the import side. Some commercial applications are under the ITAR because of the technology involved, such as commercial satellites. Some categories are enumerated, very specific. Some are very broadly defined. The ultimate goal under export control reform, which started in 2013, was to have as many things enumerated in the ITAR as possible so that there are fewer gray areas. They're working towards it. Aircraft, ground vehicles, military electronics, and certain categories within the ITAR and the U.S. munitions list have already gone through export control reform, and they are enumerated. Many of their items were moved over to the commerce regulations, the EAR, et cetera. So they're trying to, the government is really very, very deeply committed to making the regulations make more sense and be more user-friendly to everybody who uses them. And that, I've been saying that for 30 years, that the government's intent is to do that. Well, the U.S. government's actually doing it now, which is good, since about 2013. Classification of a product, we don't mean classified as secret or top secret. We're talking about classified if it's on the U.S. munitions list or not, and if it's not, if it's on the commerce control list. That's what we refer to as classification, and that's what we use to determine if licenses are required. This is the U.S. munitions list. This is the first half of it, categories 1 through 10, and that shows you what's in them. I'll just grab one at random on the right side. Category 8. It's always Roman numerals, by the way. Aircraft and related articles would be there. And as you can see, it covers, well, this is the first half of it. This is the second half. If you notice, in total, there are 21 categories. The first 20 of which, if you were self-classifying your items, you could assign something that category. Category 21 is for things that have not been contemplated, emerging technologies, etc. Only the U.S. government can put something in category 21. And in my 30 years, I don't think I've ever dealt with a category 21 item. Usually, always, they can wind up fitting it into categories 1 through 20, just so you know. Just because you don't understand something, just throw it in category 21. That usually doesn't, you can't really do that. The government has to determine that. And that's the State Department when I say the government. Registration, you have to be registered with the DDTC, Directorate of Defense Trade Controls, if you're going to work on any part of the manufacturing process of defense items, anything that's on the munitions list, or perform any defense services to anyone, then you're required to be registered. You do not have to be an exporter. So if you either manufacture or export U.S. defense items, then you have to be registered with the DDTC. That is a requirement. If you don't do it, you're in violation of the law. And that's the registration requirements are covered in Section 122 of the ITAR. Remember, the ITAR goes from sections 120 to 130. So this is like the third major section of the ITAR, covers registration requirements. It's only about 2 paragraphs long, but it's fairly clear when you have to be registered. Here's a registration myth. Well, we're not manufacturers, we don't have to register. Well, manufacturing could include all kinds of processes. It's best to talk to an expert just so you understand. Even though you only do finishing on a part, that is part of the manufacturing process. Even if you only do testing of a manufactured article, that is considered part of the manufacturing process. So Tom had said, the way our answers to questions almost always start with the term, it depends. Another thing that we're very apt to tell you is we don't like the use of the word only when you're trying to get away from something being classified as under the ITAR. Well, it only does this. We don't like the word only. Only is a lot of people have gotten into trouble over the word only. So, we try not to use that. This is the actual, the paragraph that says any person who engages in the U.S. in the business of either manufacturing or exporting defense articles or furnishing defense services is required to register, blah, blah, blah. So if you don't engage in exporting, the underlying portion says, doesn't matter. If you're dealing with the USML in any way, shape, or form, you have to be registered, even if you don't export. What it doesn't mean is that you now have a certification from the government that you're allowed to work on defense articles, that your company is compliant. You are simply notifying the government that you're going to be doing this. If they were to turn around and investigate you and decide they didn't want you in that business, I guess they'd have to take you to court. But we get a lot of inquiries from companies saying, are we ITAR certified? Or how do we get ITAR certified? And they think it means you can do things without a license. It's not. There is no ITAR certification. It is simply a registration. You are putting the U.S. government, State Department in this case, on notice that you are either going to manufacture or export defense articles, or both, or provide defense services to somebody. And it's fundamentally just a way of letting the DDTC know. They want to know who's building the U.S.'s stuff from a defense standpoint. I mentioned defense service probably 3 or 4 times in the last couple of slides. It means assistance, including training in the development, design, engineering, manufacture. There's a whole laundry list there you can read. I just want to point out demilitarization. If you impart to some foreign person the knowledge of how to demilitarize an item, such as taking a military helicopter and removing all the military stuff to turn it into a civilian helicopter, that process would be controlled by the ITAR, because the understanding is you could either reverse engineer or reverse the process and figure out how to militarize something. So the ITAR is concerned with demilitarization techniques and processes. Providing technical data, whether in the U.S. or abroad, to anybody. And if you're going to, even if you're training foreign forces and units of friendly countries, that is a defense service. So if it's involving defense articles, defense items, technology, or just if the training or the furnishment that you're doing to people concerns anything to do with defense or military, it's a defense service by definition. Once again, we come to a pause point for questions. Mr. Reynolds, if you have anything from somebody, or I'm going to mute for a second here and let you read.
Thanks, Ray. We do have a few questions from some folks. The first one here is, if I take a laptop out of the country but I don't show the information on it to anyone, is that considered an export?
Okay, that is a good question, and it shows somebody was paying attention to the slide. The answer is yes. The quick answer is yes. However, of course, the export compliance person's answer is whether or not it's an illegal export or whether or not it required a license, that depends. If you keep the laptop under your positive control at all times, meaning you do not leave it in your room, you know, it's tucked under your arm the whole time, yeah, theoretically, although it's still an export of the data that's on it, you haven't actually committed an export violation. That being said, you can commit an export violation completely unknowingly. There was we'll refer to a very senior official of a very famous and large aerospace company for whom I worked, who went to China because the company had its government business and also its commercial business. And being a very senior official, this person, you know, was there on commercial business, selling commercial helicopters to the Chinese, perfectly legal. Took his laptop to China with him, as people were wont to do. He was warned about being careful, and why don't we give you a sanitized laptop so you can still do your thing, but you don't have any data on it? Well, no, he didn't want that, etc. And the bottom line of it is, went out to dinner with some folks, forgot something in his room. Oh, I forgot to bring my wallet or whatever. Goes back to the room, finds the maid in his room at a time when the maid should not have been there, and there was a device plugged into one of the USB ports on his laptop, and they were copying everything on his hard drive, even though it was, you know, password protected and all that. They can clone your hard drive, send it through the wall by Bluetooth or other means, and then, you know, Chinese intelligence in this particular case was able to break the code on his hard drive at their leisure, long after he was probably going to be out of the country. Luckily, he happened to catch it. He pulled the device out. We don't know how much of his data went to the Chinese intelligence, but it was a disclosure on part of this company I worked for. So you have to be very, very careful. So yes, taking a laptop is an export. Whether or not it's an export violation, it depends on a lot of things. What's on it, who has access to it, etc. Companies, we've advised many companies to just, if someone travels as a course of regular business, and if they normally have access to ITAR or other control data, that you have a travel laptop for them to use. Some companies will turn off the smartphone attachment function so that you can't possibly send attachments to somebody in a foreign country. There are lots of IT creative ways to keep yourself in compliance, but yes, it is actually an export.
Great, thanks, Ray.
Other questions? Or?
Yep, a couple more. This one's around the definition of a foreign person. Is a work visa, the question is a work visa different from other visas as applies to the definition of a foreign person?
No, it is not. A visa is a visa. A visa means somebody is legally allowed by the U.S. government to be in the U.S., and there are H-1Bs for employment. There are student visas. There are spousal visas if you marry a foreign national and bring that person into the country. I mean, there's lots of different reasons, but for the regulatory ITAR and EAR purposes, a person with a visa is a foreign person for these purposes. Doesn't matter what kind of visa it is.
Great, thank you. Another question here, the categorization of technical data on the USML. It says, what category would you use for technical data other than category 21?
Oh, well, technical data, as a matter of fact, let me see if I can just back up real quick here. Okay, these are the categories. The technical data for any of these categories is covered under that category. For instance, if you have, I use category 8. Category 8A, subletter A, I just know that, it's not on the screen, it would cover an aircraft, an enumerated aircraft such as a fighter, a bomber, something military. And the technical data, such as the drawings or specifications for that category 8A item, may be category 8H. But the technical data for an article on the U.S. munitions list is going to be under the same main heading category. It'll just have a different letter or number underneath it. The same thing with the EAR. The EAR is going to have an item is going to be in the Commerce Control List. It's going to have an ECCN, Export Classification Control Number. And in the case of, we'll stick with our example of aircraft, category 9A991, which is the CCL, that's where most aircraft are kept. 9A991 tells us it's a certain type of aircraft, commercial aircraft, non-military, but the technology for that, which may or may not be controlled, is going to be 9E991. So A means the item itself, E means the technology that describes it. So the same thing, the U.S. munitions list has subcategories, but no, you don't use category 21 just because it's technology. The technology in and of itself is under the same category as the item that it describes. Hope that is clear.
Yep, thank you. We are back to the traveling laptop, Ray, with another question.
Okay, of course we are. My favorite subject.
So the question is, the movement of the data on the laptop across the U.S. border, is that is or is not a violation if the movement was not licensed, even if nothing was transferred?
Yes.
So it's a violation.
Nothing was physically transferred, I guess is what they're saying, right? You know, so I want to make sure I understand the question.
The way I read the question is that let's say a laptop in the U.S. has controlled data on it. It would require a license to take it to Germany, for example, and no license was obtained. Even if they take it there and don't, it stays within the U.S.
I gotcha.
possession the whole time.
Right.
Yep.
Yeah, okay, good. I'm glad you explained that, because I could have gone off on a completely different tangent, which would not have answered the question. Yes, in this case, the laptop and the data on it have been exported. Now, whether or not there is an export violation, if you honestly and truly kept it physically in your control and didn't hook it up to anyone else's system, nobody ever put a flash drive in and copied. No, if you slept with the darn thing, you have not committed an export violation. What you have done, though, in carrying this device someplace without a license or at least some kind of controls on it, you have left your company at quite a bit of risk. So there is risk, but in this particular case, as I've described, you've got the thing handcuffed to your body or, whatever. It never leaves your sight. No, there isn't a violation there, but you are definitely putting your company at risk by doing that.
Thanks. And if we misunderstood that question or got the assumption wrong, let me know and we can try to clarify it in a follow-up.
Yeah, please do.
Okay, one more here and then we'll move on. What type of document should I have which confirms that all of my products that my company makes are EAR 99?
Well, there isn't going to be a single document that says, verily, these are EAR 99, unless, and here's one of those it depends kind of questions. If, let's say, your product line is limited to, we'll say 20 part numbers or 20 categories of items, widget 1, widget 2 through 20, etc. If you have gone through and either diligently self-classified everything, and you are willing to stake your reputation and all of the other, the violation stuff we mentioned, and you're really, really certain that this is EAR 99, there is no paperwork or a single document that's going to say that you did that. However, if you were to be audited or if there were a suspected violation or a disclosure, you would want to show the processes and steps you went through to come to that conclusion. So, once again, it's something you may never have to send somebody, whatever, but let's say you had a suspected violation or just you had a focused assessment or something, and somebody from the government, an auditor, said, okay, show me how you arrived at the AR 99. You want to be able to show how you got there. Now, if it turns out you're wrong, you did it incorrectly, but you exercised reasonable care, you just came up with the wrong conclusion, that's going to be a violation, but it's not going to be a real bad one. They're not going to fine you, put you in jail probably. They're going to say, okay, yeah, verily, your corrective action is to train your people a little bit better at classification, be more careful in the future, and you're subject to re-audit in a year, something like that. There's kind of that. Now, of course, if you don't know and you're not going to self-classify, you can do what they call a commodity jurisdiction request. Hey, this item is, we think it's ITAR, but I don't know, we think it should be commerce control because it's so old, because you can buy these things in the open market in other countries. I mean, there's a lot of excuses, none of which is a hard and fast, okay, if this condition exists, then it's not ITAR anymore. But if you have a commodity jurisdiction request, hey, here's this item, here's the description, here's the drawings, blah, 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 here's the reasons why we think it should be EAR 99 or under the EAR, under a ECCN number, whatever it is, you get your answer back in writing formally from the government, in this case, the State Department, and they say, yes, the State Department agrees, this item formerly on the U.S. munitions list is now EAR 99. That is as good as a golden ticket as you're ever going to get. You get the CJ, commodity jurisdiction, frame it, hang it on your wall, whatever you want to do. So now, if you get that audit or that question from an auditor and they say, hey, how did you come up with EAR 99? You whip out that piece of paper that says, we have a commodity jurisdiction request on this date, and the State Department told us this is EAR 99. Done and done. Put a period on it, stick a fork in it, you're done. So that is one way you can get. But of course, practically speaking, most companies don't only have one or two products they can afford to do that for, because there's a lot of time involved and you have to have people research it, etc. But in theory, if you have a commodity jurisdiction, or in reality, if you have a commodity jurisdiction that says something's EAR 99, that's what it is. That is the most definitive proof you can have. There's also a CCATS. There's other things you can get from the Commerce Department. For instance, if you strongly suspect or have reason to believe that it's definitely not ITAR and it's EAR, but you don't know if it's EAR 99 or not, or if it has an ECCN number, you'll do a CCATS, and it pretty much has the same effect as a commodity jurisdiction. If you have a CCATS saying, yes, this item is EAR 99, that's another pretty solid piece of evidence that it's EAR 99. I hope that answered the question.
Great, thanks. We have more questions, but we also have more slides to get through, so we're going to continue on at this point, and then we will address more of these later.
Okay. The same way I had that big long description of what the ITAR was, the EAR is even longer. 15 Code of Federal Regulations, Chapter 7, blah, blah, blah. It has the whole deal, but essentially it's parts 730 to 775 of the CFR 15. So that's what the EAR is. You know, it's a big long definition, but it can be summarized in 3 letters, EAR. That's the way we like it. So Department of Commerce, Bureau of Industry and Security is over that. We kind of, I don't want to beat it completely to death, but if it's for commercial or dual use, meaning commercial and military, it's controlled by the EAR and administered by BIS. And many items that are subject to the ITAR but don't necessarily require a license, they may have an ECCN number or whatever, but that's when you get into, okay, it's 9A991, it's an aircraft, doesn't require a license. You'll look for reasons for control into certain countries, and for certain uses, it may or may not require a license. So that's definitely one of those, it depends. You have to look a little bit deeper. Okay. Why isn't that clicking? Okay. Hold on a second here. Okay. The Commerce Control List, as I said, it's the listing that the EAR uses to classify items. Very extensive. It applies ECCN numbers to things. Very complex. Not for the faint of heart. If you've never done a EAR classification before, you could possibly get yourself into trouble. It's always best to have an expert at least, teach you how to do it, if nothing else, if not just outright do it for you. And there's 5 product groups within the EAR. Technology and tech data is larger. There's more of it out there. Software, there's a little bit less of it, but it's definitely an item. Material, and then all the way down, test inspection, production equipment, and then systems, equipment, and components are at the core. And that's the smaller, but that's the more systems and physical item oriented product group within the EAR. We're not going to go too deeply into that because that's, it's going to take much more time than we have. The purpose of the ECCN is to clearly identify the component, material, or technology, and to see if licenses, restrictions, and exceptions may be applied to export it. Once again, you don't always need a license. And if you're going to export items under the EAR, knowing the ECCN is very critical. An example I mentioned before, 9A991, aircraft and gas turbine engines, not controlled by those other 2 ECCNs. So whenever you look something up in the CCL, you have to, when it makes reference, this is not controlled by 9A001 in this case, you need to go to that 9A001 and make sure that you're not under that, to make sure that you're 9A991. 9A992, complete canopies, harness, and electronic release mechanisms, once again, aircraft type related, but those are just examples of ECCNs. The Export Administration Regulations consider these factors when determining licensing requirements. The ECCN itself, the destination it's going to, meaning country, and the end user or end use. Keep in mind that as factors evolve into transactions, such as you discover that, well, it really isn't going to be used by a hospital, it's going to be used by a police department for law enforcement or the military, you want to make sure that your ECCN is kind of, if it's going to be a living number, at some point you have to finalize it, but just as situations change, you may have to resharpen your pencil as far as ECNs go. And so may the license requirements because of that. Just something to keep in mind. Okay, the EAR, put together the 2 dots on the left, ECCN plus destination determines if licensing is required or not. Once again, there are exceptions you can use for government, strategic trade agreements. There's a lot of different exceptions in the EAR, and as opposed to the ITAR, in which most items require licenses, the EAR is most items do not, but you do have to know the ECCN, etc. Okay, okay. All right, so there we go. All right, a little bit about the OFAC, Office of Foreign Assets Control. Department of Treasury administers sanctions against targeted foreign governments, individuals, etc. It's the way of the U.S. exercising its muscle economically to enact our foreign policy goals. I mean, it's simply, you did something we don't like, Putin or whoever you are, so therefore we're going to freeze your assets someplace. And when you hear about freezing assets of certain entities and countries and things, that's who handles it. It's all about the dollars there, and it's using our control over money to get people either to come around to our way of thinking or to make it really costly for them to not do so. And of course, the jurisdiction of OFAC applies to all U.S. persons and companies. All right. Right now, please don't take this list of flags as a finite list, such as printing it out and sticking it on your office wall and say, hey, if I'm dealing with any country but these, I'm good to go. This is kind of an example of certain countries. I mean, you probably hear their names on the news a lot. Their names on the news a lot. That's the first indication most people get that there's a sanction. But all these different kind of countries have varying levels of sanctions and embargoes against them. And once again, it's pretty complex. If you notice the asterisk that's down there next to Cuba at the bottom, certain activities for Cuba may be allowed if licensed by OFAC. They're easing up on it. But the day that the White House announced that we're we're taking Cuba off the list of state sponsors of terror. Didn't change anything as far as you and I are concerned. There's still steps you have to go through, and it's probably going to be a gradual process. Like, for instance, you can go to Cuba now on humanitarian reasons, visit family members, but you can't just, even though that one cruise ship went down there, you can't just jump on any cruise ship, go to Cuba, and have your vacation there. There's still regulations that they're trying to work out, regulatory restrictions. Same thing with Vietnam. We took Vietnam off that list. As far as these regulations are concerned, nothing's changed with respect to Vietnam. So just keep that in mind, that an announcement on the news does not change the regulations. The regulations themselves have to be changed by the agencies that control them. And that's usually quite a bit slower. Here's some of the reasons for OFAC sanctions: narcotics trafficking, terrorism, blood diamond trading. That's diamonds that they'll do anything to get out of the ground, including slave labor and killing people. Weapons of mass destruction, the non-proliferation of those. And I kind of added this one. We only just used to have that top four. What we refer to in the history world as adventurism. That's a 19th century term. It's a good one. Putin annexing Crimea and taking over little portions of the Ukraine here and there, or massing his armies on the border of Ukraine. That's what they used to refer to as adventurism. And that's why Putin and his cronies are sanctioned. Once again, we withhold dollars from them to show them that we are displeased with what they're doing. So that's the way OFAC works. The lists are designed to keep you away from certain people, companies, countries, etc. Every company who deals with foreign companies, whether you're in the ITAR world, EAR, if everything's EAR 99, doesn't even matter. If you have to do with international companies, persons, etc., you need to have a denied party screening program of some type, because a person who's on one of those lists and you don't know it, you are dealing with someone on a sanctioned list, and that is in and of itself a violation, possibly a criminal violation, depending on which list the person's on. The number of lists that we traditionally check is very, very long. There's like 30 different agencies and including Interpol, NATO, you name it. So when you're dealing with foreign people, you want to make sure you have a program to vet them, to make sure you're not dealing with a sanctioned party. These are the lists as they currently exist. Department of Commerce has the denied party list, unverified list, the entity list. Department of State on the left, the blue heading, has non-proliferation sanctions for weapons of mass destruction. The Arms Export Control Act debarred list. Remember I said you could be debarred from doing exporting for a certain period of time, so that's where that comes into play. Department of Treasury has the longest list. SDNs, specially designated nationals, foreign sanctions, and evaders list. It goes all the way down. Sectoral sanctions, non-SDN Iranian sanctions. They've got their own little chapter just for the country of Iran, etc. So these are the lists that would need to be checked to have a robust compliance program before dealing with anyone, and that's a customer, supplier, you name it, hiring somebody, hiring a foreign national, or a U.S. person. U.S. persons can be on these lists as well. So essentially, you need a robust list way of checking people for sanctions. A lot of people use freight forwarders. Here's a word about that. Oh, we hear this all the time, but my freight forwarder takes care of everything for me. Well, you're still the U.S. principal party in interest, U.S. PPI, or the exporter of record when you deal with a freight forwarder. You're just dealing with them. You're giving them permission under a legal letter of authorization, or to sign certain documents, including export control documents, AES. You're empowering them to do certain things on your behalf, but they're not the exporter. You're still the exporter. Even if your foreign customer directs you to use their freight forwarder, your customer is the foreign party of interest and cannot be, by definition, the exporter. You're still the exporter. Many, many companies have gotten into trouble by making that incorrect assumption. Hey, I've got a freight forwarder. I'm not the exporter. You are. Manufacturers and forwarders still share responsibilities under the law. One of my many mentors back in the past referred to it as the Coke bottle principle. If you're driving down the road in your pickup truck and you throw a Coke bottle out the window of the truck, and you're guilty of littering, but the way the regular law works, if they don't see you throw it out, no one's ever going to know that you're the one who littered. Well, the way the ITAR and EAR regulations work, somebody's going to pick up that Coke bottle and say, oh, Coca-Cola, and they're going to go after the Coca-Cola company. So that's what we call the Coke bottle principle. So in other words, if you are ABC Corporation and you have an item that you proudly put your name on, and you sent it to somebody in Florida, within the U.S., no intention of exporting it, and it winds up in Iran or in the hands of somebody who isn't supposed to have it, the government's going to come after you and say, ABC Corporation, your widget wound up in an Iranian nuclear power plant. How did it get there? And if you weren't duly diligent, didn't screen your parties, and put disclaimers on your shippers that this is not to be re-exported, blah, 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 you could be in violation without even knowing it. It's like, we didn't even know this thing was exported. Well, too bad, your name is on it. So it's very, very serious. The burden of proof is definitely on you to prove innocence. It's not the other way around. Here's some guidance from the Department of Commerce, BIS. Hiring a freight forwarder does not relieve you of any responsibility. Forwarders are responsible for the accuracy of the information. That's why they have to be registered as freight forwarders. Both the forwarders and their customers should be aware of red flags. So if you see something that just doesn't look right, and there's a whole list of red flags, but like somebody wants to pay cash for an item that's normally covered by financing, somebody has no knowledge of your product but wants to buy it anyway. These are the kind of things that this transaction may not be on the up and up. Keeping in mind that both freight forwarders and the person that they're forwarding for can be subject to the criminal and administrative penalties. That's why freight forwarders are very, very closely watched, and they're going to try not to make mistakes. And if they see something wrong, they're going to let you know, because their reputation is on the line as well. But it doesn't absolve you of your responsibility. And then, of course, both parties, the forwarder and their customer, must be able to produce the records for automatic export system. It's ACE now, but same thing. It's the automated way of filing and annotating exports. You have to keep those records, even if you have a freight forwarder. And I would say 9 times out of 10, when we have new clients, they say we have a freight forwarder and we keep no records. Well, the regulation says you have to. So that's one of the first things we try to help them clean up. Go to your freight forwarder, get the records. They're required to keep them, so are you. So having a freight forwarder doesn't really absolve you of much of anything. We are at a stopping point again, very, very close to the end here. After this, there'll just be some cleanup operations. So, Tom, do we have any questions on this section that we just did?
Yeah, we do. Let's see. This first question here says, please explain in a nutshell, you are working on an international project with public domain information, so nothing is export controlled. However, you decide you had to send an EAR 99 piece of equipment to Saudi Arabia or Qatar. Would a license be required? That may be
EAR 99.
Mm-hmm.
Okay. Yeah. EAR 99 is associated with it is no license required. So as long as something is legitimately EAR 99, once again, we have to all default to what we know, and we have clients that will come in, and it turns out they call everything EAR 99 unless they know better. Well, that's obviously not the way to arrive at EAR 99. But yes, in this particular case that you mentioned, with the countries that you mentioned, that you talked about, public domain information, all that doesn't require a license. And if the resulting product or whatever is EAR 99, legitimately speaking, you do not need a license.
Yep. Yeah, and just to add on to that, we hear a lot of times from people that say, nothing that we have is export controlled. And that always kind of sends an alarm bell off in my head, because with very few exceptions, the United States has the ability, if it wants to control everything. So when someone says, like particularly in a manufacturing environment, nothing is export controlled, they may mean that there are no license requirements for a particular country, but you really have to be careful with those kinds of blanket statements, because the regulations pretty much control everything.
Yeah, like we like to say, it's everything from stealth fighters to paper clips has export controls. The controls may very well be EAR 99, no license, we don't care, but that is in and of itself a control, simply because you have to consider it before you export.
Yep. Here's another question, Ray. How do U.S. export audits work? Which government entity audits, and is it typically a whole company audit, or is it a shipment-by-shipment audit?
Okay, that is a good question. Once again, in fact, if I say 1, 2, 3, Tom and I can both say it depends, but I'll just say it for now. It does depend. It depends on which transactions and what they're auditing. If it's a EAR type transaction, the BIS might audit you. If it's ITAR items, once again, it doesn't necessarily mean it's a violation. I'm just saying, you know, it's your turn in the barrel to get an audit. It'll be somebody from Department of State. If it's more of the on the Treasury side of the house, OFAC. So it really does depend on what it is. What most people tend to see when they're just a normal exporter of products, and let's say you have a mix of ITAR and EAR type products, you may get what they call a focused assessment by the U.S. Customs and Border Protection, CBP. And that's, you know, yeah, they don't call it an audit. I don't know why they don't, tell you the truth, but they refer to it as a focused assessment. They may look at a sampling across the boards of all kinds of exports that you do. Now, if there's two types of audits, and by the way, Export Solutions, we will perform pre-audits for you, and those we'll come in and we call it a gap assessment. You want to, or gap analysis. We want to look for, you know, gaps in your system where you might be vulnerable, and it's one of the things we do for people that, you know, helps to keep them out of trouble in the future. But, you know, so it really isn't an audit unless it's being done by somebody who can penalize you like the government. But that being said, the functions that we both go through, whether we're doing an audit, I'm going to assume whether we're doing a gap assessment or a gap analysis, or if the government is coming in doing an audit, or if you're getting a focused assessment from CBP, it doesn't really matter. The definition of terms is kind of the same as much as there is a procedural. Tom, can you still hear me? Something's beeping at me.
Yeah, I can hear you, Ray. You're good.
Okay. It's just, I just want to make sure it's an incoming call that I know who it is. I can ignore. Okay. Anyway, so you may have a procedural audit, which is we want to look at your overall exporting system. The most common type of gap analysis that we do. We come in, and what I like to say is we think of your company as a big long tube, and you pour, you know, you pour purchased items into one end of it, you shake it in the middle, and then products fly out the other end of it. Well, everything that happens inside that tube, that starts from you're receiving to when you ship something out, is what we're going to look at in a gap analysis of your company. Because we want to know what happens from start to finish. That's a procedural thing. We're going to look to see if your procedure's right. What the question alludes to is individual transactions. That's a transactional analysis or a transactional audit. Generally, those are going to be triggered by a couple of things, one of a couple of things. Number one is they're doing a procedural audit. They just find so many gaps that the auditor or somebody like us stops and says, you know what, let's stop the procedural audit right now. Show me some transactions, because it doesn't look to me like you've got the capability of being compliant. So that's when a transactional audit may take place. The other example of when a transactional audit may take place is if there is a known or suspected violation. You know, so, you know, once again, those are two ways. Either your system becomes in question, and so we want to see some individual transactions, or all of them. It may be 100% audit. You know, you don't know. Whoever's doing the audit is going to determine how much they want to see. Another reason for a transactional audit would be if they're just doing a random sampling of shipments within the procedural audit. If we find one that's not compliant, oh boy, that's bad. Then we find another one. Also, we realize even though your procedure is capable of sustaining compliance, it's not doing it. It's not doing it. In that case, we may recommend a transactional audit, because it may lead to a voluntary disclosure on your part. You know, you might say, hey, look, you know what? Even though we have a system that theoretically works, we're not using it right. So so those are individual transactional audits occur, generally speaking, when there's reason to do so. Otherwise, it's usually procedural. Hope that addresses it.
Yep, thanks. Okay. We have about 15 minutes left, and we have a lot of questions. So I know you have more slides, Ray, but I'm gonna err on the side of getting through more questions than finishing out.
Okay.
The rest,
okay.
I think the rest of the presentation is wrap up and next steps, right?
Yeah. Yep.
Okay.
That's exactly.
All right.
Oops. Yeah.
So the next question here is, and this is getting into ITAR licensing, which I don't think we covered a whole lot, but so some of the terms here may be new to people, but does a temporary export of technical data need a DSP-5 or a DSP-73?
That's a trick question. There is no such thing as a temporary export of technical data. By definition, for once technical data exports, it's permanent. Even if you know, I send you a drawing and you promise me to send me the drawing back, well, if I read the drawing, I have it in my head. There is no such thing as a temporary export of technical data. It is always permanent, and in the case of this example, it would be a DSP-5 license for technical data.
All right, thanks. Next question here. We have an EAR 99 product, and Customs says we still need a State Department license. Is this true?
No. It depends. No, I don't think the State Department would tell you that. Of course, the State Department.
Sounds like Customs does it, maybe.
Yeah.
So
probably. Yeah.
Go ahead, Ray.
Yeah. No. Well, yeah. Exactly. What I'm suspecting is somebody who is some governmental person involved in the process. In this case, probably Customs is questioning whether or not your EAR 99 item really is. They may be saying, hey, you know what? This is an aircraft part that goes on an F-16 or whatever. We think it should be ITAR. That may be kind of a polite way of saying, you know, we're seizing this shipment because we think you did something wrong, but the State Department per se isn't going to tell you that you need a license for something that's EAR 99. Once again, we're talking about legitimately EAR 99. If for whatever reason, remember we went through the laundry list on, was it the first question, on things that you can use as proof that something's EAR 99? Short of that, no one is really going to tell you that, yes, it's EAR 99, but it still needs a license. That's a non sequitur. It just doesn't go together.
Yep. Okay, this is back to audits. Are compliance audits by the government made only for cause, meaning when you have a problem, or is there some type of mandate or rule that the government will randomly sample populations of DDTC companies and audit them?
Yeah, I can see where the question is going. You can be audited as a result of a violation or suspected violation. Could even be a whistleblower. Disgruntled ex-employee says, hey, you know what? This company I used to work for is doing this, this, and this. You know, there's a lot of reasons somebody can blow a whistle or get you audited, you know, for cause. As far as can the government do random audits? Yes, of course they can. Do they have a list of X number that they would like to do in a year? Yes, they do. Each office, you know, hey, you know, we're going to try to get seven random audits done because they just want to keep the system honest in general. Yeah, all that may be true, but realistically speaking, currently they don't usually have enough personnel to do these random audits that they would like to do. What generally we've seen happen, and we get business through this process, would be, you know, all of a sudden your company gets a letter from the Department of Commerce or Customs or something. It says, congratulations, you've been selected for a random audit of your export compliance system, you know, yada, yada, yada. And then they'll say, however, due to personnel constraints here at the Department of, you know, Commerce, we are directing you to hire an outside audit firm, such as Export Solutions. And it would have to be somebody that you haven't dealt with in the past. So if you're not a client of ours, you get one of those letters, you may look us up on the web and find out, yeah, these guys do internal audits. And then what we would do is, instead of a gap assessment, which is what we call that, we would actually perform an audit, you know, as if we were the government, and then the government gets a copy of the audit report. So you wouldn't be able to filter it or anything like that. So if the government directs you to hire somebody to do an audit, you might as well think of it as a government audit, but you're going to pay for it. And they'll do that because they generally don't have the personnel. But ideally, in a perfect world where the government has all the resources it needs, both situations. You may get an audit for cause. You may get an audit just because your number came up and was pulled out of a hat. All right.
Great.
That hopefully that covers it.
Yep. Thank you. This question's about best practices, Ray.
Mm-hmm.
And it basically says, is it common or usual for a supplier to send an end user statement at the end of the year and want to know what we did with all of their material during that year? Basically provide all the end use information for all of the material.
Yeah, they might like to do that or to have that information, but that would be the kind of thing where you would have justification to send them a bill. If you want us to do this, here's our estimate of what it's going to cost. So no, they're not entitled to it. If an end user certification is required before or as part of the purchase itself or the contract or whatever, that's all those things that are negotiable terms as part of a commercial contract. If it's required by law or regulation to have an end user certification, such as the requirement for a DSP 83, for a licensed type item, all these things, would be on a contract by contract or shipment by shipment basis, essentially. But no, go ahead.
It's a little bit after the fact too, because the purpose of end use certificates is to make sure that you don't ship something in violation of a prohibited end use. So coming in at the end of the year and saying, hey, tell us what all of our items were used for, is a little bit like too little too late kind of information, I would think.
Yeah, exactly. It would be like the next day, a policeman asking you, last night did you drink and drive? And you come out and say, yep, sure did. It's a little, as you say, after the fact. So it would not be reasonable for a company to send you, an after the fact end use certificate. I mean, there's no legitimate reason to do it. As I said, if you want to provide it, you're going to be at some kind of risk if you find something that was not done properly, but you'd probably have a right to be reimbursed for the effort it takes to do it. I wouldn't. I would just say, no, we don't do that.
All right, great. Well, folks, we're out of time. Ray and I both have meetings to get to, and so we do have other questions coming in. I appreciate all the input. It was a good session, hopefully, for everybody, but we're going to have to stop at this point. If there is a question that was either discussed or one that we didn't get to and you would like to follow up with us afterwards, we'd be happy to try to address that with you offline. So I just want to thank everybody for attending this session. Thank you, Ray, for all the good information that you provided. And just a reminder for folks, we are getting some people out the slides again. Check back on our website in about a week. Go to exportsolutionsinc.com. On the upper part of the homepage, you'll see a button for webinars. If you click there and go into that section, look for the section on archive webinars, and you'll be able to download a copy of the slides and also view a recording of today's session. So thanks again, everybody, for attending. I hope this was a helpful session. We hope to see you again on a future webinar, and have a great rest of your day.
Take care, everybody. Bye-bye.
Goodbye.